Hi everyone, today's lecture we are going to discuss the various legal issues that you need to consider as a certified personal trainer. And just a heads up, the video portion of this screen capture is not working, which is why you only hear my voice. So, exciting times. So we're going to start off just kind of by reviewing some things here first. A long time ago in the very beginning of the semester, we talked about SOAP notes. And if you remember that acronym, it stands for Subjective, Objective, Assessment, and Plan. And when we discussed SOAP notes in detail, what we discussed was how you can utilize SOAP notes to help you better prepare, not only working with your client, but also to prevent some possible legal ramifications. So remembering what goes into SOAP notes is super important because what we know is that if you utilize SOAP notes properly, then you're going to help make yourself be less negligible in the future if an event ever does occur. As a warning, SOAP notes do not protect you from litigation. In other words, just because you take the best notes ever does not mean that someone can't still sue you. However, it can protect you in that it will at least give the jury, whoever's going to decide your case, some indication to how you handled the situation. So making sure that we're really careful about how we take notes, but also making sure that we take them confidentially, and that we're staying within our scope. So this was a recent case. You can click on the hyperlink to read more about it. But it was a woman, Linda Baldy Perry, who sued her personal trainer. She sued her personal trainer and won the lawsuit, and she was awarded close to $1 million. And the reason why she sued her trainer was because she claimed that she was hurt during a session with her personal trainer. If you read the story in more detail, you're going to see that actually as a result of this lawsuit, the actual location of the gym, since it was a smaller gym, had to be shut down. And so while we think, oh, $1 million doesn't sound like that much, if you're dealing with small mom and pop gyms, absolutely, especially if the person doesn't have liability insurance through the gym, if they just have liability insurance through themselves, this could be detrimental to a personal trainer. So let's talk about some legal terminology here. When we say the word criminal, what we're referring to is an unlawful act that's made by a congressional or state legislative body. So an example in the fitness world or fitness and health world would be if someone gave unlawful medical or dietetic services by a personal trainer, which is reserved for licensed professionals. So while we may be certified personal trainers, we are not licensed professionals. And so when it comes to medical and dietetic advice or services, we need to make sure that we are referring out to individuals who are licensed in those specialties to be able to discuss those things with our clients so that we don't make sure that so that we aren't negligible in the future if something does happen. So again, how do we prevent this from happening? Stay within our scope according to our certifications. Most of the fitness certifications do a really good job nowadays of describing what you can do within your scope, particularly for nutrition. And so making sure that you stay within your scope. Unfortunately, a lot of people in the health and fitness industry do not. And so that can cause issues for them. It may not happen immediately, but you can almost guarantee, because we do live in a very sue-happy culture, that eventually they will have some sort of issue when it comes to that. We can also make sure that everything that we're doing is authorized. So what acts you are authorized to administer in areas you are authorized to advise on. Just making sure that, again, not only staying within your scope, but you're kind of using common sense as far as what you are, the information that you're giving your client. Another term or another legal term is contract law. This is where you promise of something of value with a verbal or written document. So to be clear, it doesn't have to be a written document. If someone has a recording of you saying that you're going to give something of value, then that becomes that verbal document under contract law. Tort law is wrongful omissions of injury, wrongful acts of omissions. And this is probably where you see a lot of issues, this and negligence, which we'll talk here in a second. Generally is present in personal injuries or wrongful death. So again, why we see this a lot in our field, basically with injuries or death. If there's an injury to your client, the Linda Baldy Perry versus Trainer case is a perfect example, and it's becoming more and more common. Similar to the tort law is negligence claims. So tort law, to be clear, is an actual law. Negligence claims are kind of surrounding that law. And essentially, in order for this to happen, there must be some sort of proof of negligence. So this could be proof that the personal trainer failed to act to protect their client. So for instance, if someone, while you were training your client started going to cardiac arrest, if you are CPR certified and you don't act on that, you could be held negligent. Okay? And because you didn't act on that, it led to injury or harm. Mental anguish alone is insufficient, although I'd like to say that that's starting to change, meaning courts are looking more and more into not just physical harm, but also psychological harm as well. Economic losses, these can include medical expenses, lost wages, mental distresses, shock, anxiety, and humiliation. If you are found liable for negligence, you actually run the risk of having to pay a large sum of money to compensate for that physical, economic, and mental harm. So essentially what this is saying is that even if you have liability insurance, and even if you have covered all of your bases, you can still run the risk of having to pay if you are held negligent. So the best thing to do is to prevent that from happening in the first part. So essentially, rather than omitting to act, you act when you need to. So I have probably scared you all now, right? You've heard horror stories, I'm sure, already in the field, and then going over some of these legal things can be quite intimidating. So always remember that some of those kind of gold standard processes that we talk about in the very beginning, remember why those are so important. They are often overlooked and often not done because of hectic schedules and people just forgetting and a lack of communication and or organization. So make sure that when you have clients that you have a release of liability signed, you have an informed consent document signed, and that you are taking really good SOAP notes and other documentation. Remembering the importance of good communication. My other thought here is, since we live in such a digital age, make sure that you keep all of the communication written via text, as well as on your email, as well as even voicemails. Keep all of that, download it to some sort of cloud-based storage system, and have that, because if something ever happens, the more you have to protect yourself, the better. And last but not least, you should be able to answer some of these questions. Why did you choose to do this with your client? So if you go to court and someone says that you hurt them, you need to be able to justify why you did that certain movement, right? And that is where I keep going back to saying, make sure that whatever you program with science in mind. Don't just do it because you saw it on Instagram and it looked interesting. Why is it safe for that client? If it's not recommended, why you felt like you would deviate from what's recommended. Making sure that you have proof to show why you did what you did. Be able to reference a text or research to support your why. This is so incredibly important. And this is a nice little segment from ACE, actually. This is what they call legal armor, and it's some things to help CPTs and probably all fitness professionals in that regard. Act with common sense. Make sure you're following kind of all those kind of rules that we just talked about. You're using your documentation, good communication, etc. Instruction that is current with professional standards and practices. So in other words, stay up to date on what you should and shouldn't be doing in regards to legal issues. When you go to different continuing education classes, if there is a segment on legal issues in the fitness and health field, I highly suggest you go, because this is an ever-changing aspect of our field. Check the equipment before every use. It's not just the responsibility of the gym owner, it's also the responsibility of you. So if you are using dumbbells and they're broken, if you're using TheraBands and they're halfway ripped, it is up to you to check the equipment to make sure that that equipment is safe for them to use before your clients use it. Boot camps beware. This was obviously written during a time where boot camps were becoming more and more popular. They are still relatively popular, and the reason why we say boot camps beware is because it is a form of higher intensity in physical activity. And we know the risks that are associated with that. So if you think that your client is going to engage in higher intensity physical activity, one thing that can help protect you is include that on your consent form or liability form. But also, if it's something that you think is going to be an issue or potential issue, make sure you go and get physician's release. That will help protect you if something ever does happen. Be careful with training at your home or your client's home. This is becoming an ever popular thing to do, and more clients want you to come to their space. Just be careful with that, and with that said, you're going to want to make sure you add some added kind of terminology and added text into your beginning documents, like your consent form and your liability form, so that if something happens and maybe you break something in their home, you aren't going to be sued for breaking that thing in their house. Be careful of how you touch your clients. I've talked a lot about this in class. There's a great article which I posted on Beachboard about this and about kind of sexual misconduct in the fitness field. At the end of the day, it's super important that before you touch a client, you make sure that you tell them why you're doing what you're doing, and before that, ask for permission. Because if they say they aren't comfortable with it, then you need to problem solve and figure out another way to demonstrate and or help that client with that movement. Making sure that you're careful with your nutrition. We talked about that earlier, and what you decide to guide them as far as nutrition practices. If you follow general MyPlate USDA guidelines, you are going to be fine. The second you go and get closer to more special population-based diet programming, that is where you are running that fine line of going outside of your scope. This includes advice on supplements. Save that for the registered dietitian. Just because someone you know or even yourself takes a certain supplement does not mean that it's going to be safe for the person that you were advising. You don't know their underlying health issues. Many young people have never had any kind of cardiovascular tests, so they don't know what might even be existing within themselves. And most supplements aren't even approved by the USDA. So just make sure that you aren't advising people to take supplements just because you like them. Okay. Biggest thing is knowing when to refer out to specialists in that area. If you do this consistently, you are not only going to be saving yourself from potential legal issues, but you also are going to be building rapport, because clients like to know that you have this set of people around you that are professionals that kind of can build a team of health professionals around them as well. And number 10, get liability insurance. If you do not have it and you plan on working with human beings, you need to make sure you have it. Now, many places will have liability insurance, like your big box gyms like 24 Hour and LA Fitness and things like that. However, if you decide to go to smaller local gyms, or if you try to train on your own, you will need to make sure you have some sort of professional liability insurance. And oftentimes you can get discounted rates through your certification agency. So if you're certified through ACSM or NSCA, you can go to them or even IDEA, and you can get a discounted rate for liability insurance. If you have any questions, please let me know. I look forward to having this conversation with you in more depth during lab.